Hello friends, welcome back. In the last session we learnt about the settlement of disputes outside the court as contemplated under section 89 of C.P.C and the procedure relating to that. Okay friends, now we will come to order 14, settlement of issues. Okay friends, suppose the plaintiff and the defendant have filed their pleadings, written statement pleadings are over, and the efforts of the court to get the matter settled out of the courts have been failed, and now this is the next step for the court to frame the issues or to settle the issues. Issues means in generally in the Indian Evidence Act it is called as fact and issue. Here in criminal in civil proceedings, civil practice, it is called issues. Issues are nothing but the questions before the court to be answered by the court for just decision of the case. After filing the plaint and written statement, the court has to see the pleadings and after hearing the parties, settle the issues. And this order deals with the settlement of issues. That is the questions to be decided in the suit. Okay, friends. Rule 1 of Order 14 says that issues arise when the material proposition of a fact or law is affirmed by one party and denied by the other. Okay. Sub-rule 2 defines what is material proposition. Material proposition of a fact or law is a thing which gives right to the plaintiff to sue, and material proposition of fact or law is a thing which give a right to the defendant to constitute his defense. Okay, that is called material propositions. And for framing of issues, it is very necessary that material proposition should be affirmed by one party and denied by the other party. Okay. Sub-rule 3 of Rule 1 of Order 14 says that each material proposition of law or fact shall be the subject of a distinct issue. Therefore, the court can frame any number of issues depending upon the material propositions contained in the pleadings or in the case. Okay, friends. Sub-rule 4 of Rule 1 of Order 14 says that there are two kinds of issues, that is issue of fact, and another kind is issue of law. That is question of fact, question of law. Okay. Friends, sub-rule 5 of Rule 1 of Order 14 says that at the first hearing, the court shall peruse the pleadings of both parties and hear their advocates and ascertain as to on what material propositions of fact or law the parties at variance, and proceed to frame or settle the issue so as to adjudicate the suit or case properly. Okay, friends. Sub-rule 6 of Rule 1 of Order 14 says that no issues need be framed by the court when the defendant makes no defense. Apparently, when the defendant doesn't deny any fact of the plaint, the court has no need to frame any issues in the suit. Okay, friends. And now, Rule 2 of Order 14 says that, again, Sub-rule 1 of Order 2 says that the court shall pronounce judgment on all issues, notwithstanding the fact that the court may pronounce judgment on preliminary issue. Okay, friends. Sub-rule 2 of Rule 2 says that when a question of jurisdiction of the court and a bar to file a suit before the court arises, that question shall be framed as preliminary issue, and the court shall first decide that issue before settling the other issues. And when a court comes to the decision that suit is maintainable, then it shall settle the other issues involved in the case. And if the court comes to the conclusion that the suit is, liable to be dismissed as per the answer given by the court to the preliminary issue, then the court need not frame the other issues. Okay, friends. Okay, Rule 3 and 4 are not so much relevant, and Rule 7 is also not so much relevant. Therefore, and Rule 6 also not so much relevance. Therefore, I am going to Rule 5, my friends. And Rule 5, Sub-rule 1 of Order 14 says that before passing decree, the court may amend any issue or frame additional issues if it is necessary for the proper adjudication of the suit. Okay, friends. Sub rule 2 of rule 5 of order 14 says that before passing the decree, the court may strike out any issues which were incorrectly framed. Okay, friends. That's all for now. Next, see you in the trial in civil suits. Okay.